All rise for the honorable judge.
Everybody, well, stand up.
Alright. Everybody on the floor, make sure they're shouting. Germain, Maximillian, Francais, DeMarquis, Robespier, Pendragon III, Esquire, Chief Justice for the State of San Andreas, presiding in the First Circuit Court. I hereby convene court in the matter of the State of San Andreas v. Whiskey Sauer, representing the people, interim district attorney Kelley, and his second chair, ADA Thundercocka. Representing the defendant, Whiskey Sauer, is Mr. Mack. All right. Uh, you all may be seated now.
Yeah, good hell. Excuse the Your Honor, can we get this guy removed, please?
Who is it?
This guy in the purple, he just keeps talking and yelling.
I got you. Bailiff, could you
Richard,
instruct one of the officers in the gallery to remove the gentleman in the purple?
Richard, get the guy in purple out of here. If you have to handcuff him and escort him out.
Alright. District Attorney Kelley, if you'd like to approach and read the charges against Mr. Whiskey Bauer. Sorry, Mr. Whiskey Sauer.
Sour, goddammit.
Yes, sir. So today we're going to be charging Mr. Whiskey Sauer with violation of Penal Code 8002 and Penal Code 2003, that is criminal possession of a Class II weapon, and Grand Theft Auto A.
Understood. You may be seated. Mr. Whiskey Sauer or his representative counsel, would you like to approach and enter a plea?
Can everyone hear me?
Yes.
Alright. My client pleads not guilty.
Understood. You may be seated, counselor. Alright. Do we have any motions before we enter into opening arguments?
Yes, Your Honor. I would like to file a motion to bring a witness into the case. One Mr. Dan Oakes, head nurse of EMS.
I understand. Were you...
Objection.
I got you. What's the objection?
It wasn't on the witness list.
That is correct, counselor. Were you or your second chair aware of this person having witnessed the crime?
It's not more of a witness. It's more of the interaction regarding evidence that was brought to for the case.
Could you please elaborate? I don't understand what you're specifying.
Mr. Dan Oakes, he's head nurse EMS. He was notified that an ambulance was on the road. We asked him to validate if he had any ambulances out given for a driver's test, and he said no.
I understand. So then you did have knowledge, or should have reasonably had knowledge of this person prior to the end of discovery?
Yes, sir.
Understood. I'm going to go ahead and sustain the objection from the defense counsel, Mack, and deny your motion to amend the witness list. Are there any other motions that the court needs to hear before you begin opening arguments? No? Alright. Mr. D.A. Kelley, or second chair, if you'd like to approach and make the state's opening argument.
Yes, sir. Officer Thundercocka, he was on a call, got a notification of a stolen vehicle. He pulled one suspect over, Mr. Whiskey Sauers, and was asking him about the vehicle, where he got it from. And he said that he was a part of EMS and that he was given this vehicle for a driver's license test. And it was later to be found that he actually was not a part of EMS, that he would wanted to join EMS, and that the vehicle was stolen, verified by EMS. Upon search, we found illegal items such as one Glock 40, one pair of PD cuffs, and fingerprints that were found in the EMS vehicle. Upon being Mirandized, of course, once taken down to the station, he denied fingerprints, and we went ahead and started his processing.
All right. And is that all, Counselor, for your opening argument?
Yes, sir.
All right. You may be seated. If the defense counsel would like to approach and make their opening rebuttal.
Can you repeat that? I couldn't hear you.
If you'd like to approach the stands and make your opening rebuttal.
All right, you mind if I face dump so they could hear me better?
Yes, sir. Go ahead.
All right. Settle down, guys. All right, ladies and gentlemen of the court, esteemed judge and members of the jury, today we stand before you in pursuit of justice. The charges brought against our client are not only false, but a grave miscarriage of justice. We come here not only to defend our client, but to uphold the very principles upon which this court system was founded: truth, fairness, and innocence. The burden of proof rests squarely upon the prosecution to demonstrate beyond a shadow of doubt the guilt of accused. However, as we shall show throughout the course of this trial, their case is built on shaky ground, riddled with inconsistencies, and lacking credible evidence. Our client, Mr. Whiskey, has been wrongfully accused of Grand Theft Auto, Yet, upon close examination of the facts, it became abundantly clear that there is no bias of these allegations. The prosecution will attempt to spin a narrative, but we implore you to see through the smoke and mirrors, to weigh evidence with impartial eye. Throughout this trial, you will hear testimonies and see evidence that not only exonerate our client, but cast doubt upon the very foundation of the accusations leveled against him. We will present witnesses who will attest to their whereabouts at the time of alleged incident, evidence that conjugates the prosecution's claim, and expert testimony that will shed light on the truth of matter. In the end, we trust in integrity of this court to recognize the truth when it is presented. We ask not for sympathy, but for a fair and evaluation of the evidence at hand. Our client's innocence hangs in the balance, and it's our fervent hope that conclusion of this trial you will see fit to drop these false charges and deliver justice that is rightfully deserved. Thank you, guys.
Hell yeah, brother man.
All right. Counselor Kelley or Second Chair Thundercocka, if you'd like to approach and begin an open examination of the evidence. For everyone in the court, when we do the open examination of the evidence, we will go into the DOJ Discordia, into the courtroom call channel, and everyone outside of the counselors should be muted for the call. If everyone would like to go in and head in there now.
For everyone who didn't hear him, he basically said, join the DOJ emails if you want to see the evidence, but you must be on mute.
Justice, I don't have access to that email channel to join.
One moment. Are you in the Discordia?
I am, yes, sir. And it's Father Sinister. It may also be labeled as 202L Kelley.
There you go. You should have access now. All right. We'll wait for. Looks like Kelley's in here still. Kelley, you'll share your screen and go look at any videos, pictures, anything physical evidence-wise that you want. And once you finish that, then we'll move on to your witnesses back in the courtroom. All right.
Yes, sir. Alrighty, is everybody able to see my screen?
I believe so. Yes.
Yeah.
Alrighty, so the evidence that the prosecution team has collected, I would like to point out first let me expand this image, the evidence bag where a fingerprint was collected from the first seat of the ambulance. This fingerprint was the only fingerprint found at the time when the ambulance was being processed for evidence. Second is the PD handcuffs. This person is not in PD in the police department, so they should not have handcuffs. And the last piece of evidence is the Glock 40 switch. This is a Class II weapon that does allow for semi-automatic fire. This was recovered from the person, Mr. Whiski Sauer, which if we pull up his profile here, he does not have a Class 1 weapons license or any authorization from any officer on his profile confirming that he purchased a Class 1 weapons license. Or, belay my last, Class 2. The license plate also for the EMS vehicle that was found to be stolen is 48 Delta Zulu 26, and it was in fact impounded for being stolen. And that is all the evidence that the prosecution team has to offer.
Understood. We'll head back into the courtroom and then go over the witnesses in there. All right. You may call your first witness, counselor.
Would you say? I couldn't hear you.
Sorry. DA Kelley may call his first witness now.
Alrighty, so the witness I would like to call is one Officer James Thundercocka.
Here? Right there.
This side, sir. Left side. Alright. Officer Thundercocka, go ahead and raise your hand. Do you, sir, swear under oath to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
The witnesses swear it in. You may begin your direct
Your Honor,
examination,
you may, if I could step closer so I could hear what he's saying. I can't hear him from here.
Are you yelling, Mr. Thundercocka?
Yes, sir.
All right. Can everyone hear what Mr. Thundercocka is yelling?
Speak up.
Yeah.
Say it with your chest, bruh.
If you want, you could maybe go sit on. You are sure you're shouting, right?
Yes.
I got you. Can you see if anyone back there can't hear what he's saying?
They said speak up.
I can hear you, boy.
Speak up. All right. Let's go ahead and hop back into the Discord call to do the
Okay, everyone
examination
hop
of the
back
witness.
into the email so we could hear him better. Okay, guys? Back into the emails.
I'm the first.
Yeah, brother.
Right. All right. If everyone's in here, the witness and DA Kelley can unmute and they can begin their examinations. Go ahead and only speak in here. Don't bother to speak in the courtroom just for the sake of double audio.
Sounds good, Your Honor. Alrighty. Good evening, Mr. Thundercocka. How are you doing today?
Good.
That's fantastic. That's what I love to hear. How long have you been with Los Santos Police Department?
About a week or so.
That's what I like to see. You know, as new officers, you know, we love to make sure that you're fully trained and fully equipped with the tools to patrol the streets and keep the citizens safe around. Can you tell me your current rank?
Senior officer.
Senior officer, right? And as a senior officer, your duties not only are to patrol the street, but to train the future of LSPD. Is that correct?
Correct.
Okay. Now, can you go ahead and start by telling me what happened that day, today, May 2nd, around 7:22 p.m.?
I was leaving the station when I received a report of a stolen vehicle. I responded to the call. Upon arrival, the vehicle that was reported stolen was still there. Another call had came in for another stolen vehicle, which was right around the corner, so I attached to it. Upon arrival of that call, I had witnessed Mr. Sauers fleeing in a ambulance with a broken driver's side window. Upon pulling him over, we had a conversation before him saying that he was EMS and that he was on a driver's test for EMS. And then I confirmed with Mr. Oakes from Ellis EMS that he was lying and he was not a part of EMS nor doing driver's test.
Okay. And you know, Mr. Dan Oakes, he's a pretty good guy. You know, he's head nurse. He's been on EMS for about 4 weeks. He's doing his duties just like you. You know, is there any reason to believe that Mr. Dan Oakes would lead you astray from notification of any possible ambulances on patrol for their driver's tests?
No, sir.
Okay. Alrighty. Go ahead and tell me a little bit more about what happened after you had talked to Mr. Dan Oakes.
Yeah, so after I had received information that he was not doing a driver's test, nor was he a part of the EMS, I had ordered him out of the vehicle to face away from me, his hands on his head. I then detained him, read him his rights, and we spoke some more, where he had said that he had took the ambulance in hopes to become a part of EMS, and that is when he was searched and taken in for processing, where he denied fingerprinting. So I was unable to match the fingerprint found in the vehicle.
Okay, and that would be the evidence would be the Glock 40 switch and the handcuffs, correct?
Yes.
Okay. Alrighty. And you know, as an officer, right? It's our duty to make sure that we go through the processes when we bring somebody in, to make sure that we get a picture of their person, their face, so that way we can identify them in the report, and a fingerprint to match it with their ID, their citizen's ID, in their profile. You know, as officers, how many times have people who have committed crimes denied giving fingerprints during that time of processing?
Little to none.
Right, because that evidence right there, that usually clears their name right away because there's no link, you know, right? Like, you know, that way they if their fingerprints were at the scene, it would match immediately. So I appreciate you for your service to LSPD. I'm glad to have you a part of our team, and I appreciate you for coming up here and speaking honestly.
You're welcome.
All right. If you have no further questions, the defense counsel.
Alrighty, Your Honor. I would like to go ahead and call one more witness or one more person to the stand.
The defense counselor can go ahead and do a cross-examination while we have him up here on the stand.
Okay.
Well, can you please repeat what you said? Couldn't hear you.
You can go ahead and do a cross-examination of the witness while we have him up here on the stand.
Right, no problem.
Yep.
Hello, officer. How you doing?
Good, how are you?
Good, good. Nice to hear that. Alright. So what was the reason you pulled over my client here?
Mr. Sauers he was leaving the area of the incident at a very high speed, giving me reasonable suspicion that he may or may not be the perpetrator.
And what was the speeds my client was traveling at?
Give or take 50 to 60 miles an hour, which is very high for an ambulance.
Okay. But 50 or 60 is not above the limit though.
Correct.
All right, just wanted to point that out. And give me one sec, having issues. And you said you've been on the force for a week, correct?
Correct.
All right. And how does one become a senior officer within 1 week of being on the force?
Prior experience within the department.
Okay. And then on your report, you put that he is facing charges of possession of Class II firearm and carjacking, but you guys came to the stand and said he's being charged with Grand Theft Auto A.
Yes, the amendment was put in. The report was not have.
So why wasn't the report updated?
Because we were not given the time.
You guys were given more than enough time.
Objection, Your Honor.
What is the objection?
Can we get to the point here? It seems like we're badgering.
I'll go ahead and give him a little more leeway, but go ahead and get to the point you're trying to get to, defense counselor.
All right. So what I'm trying to get to here is I mean, you know, you're a senior officer with 1 week of experience, and you guys don't have any proof of anything but a fingerprint of him on the car. There's no witness at EMS to prove what you guys are saying, and your report does not match what you guys are charging him with. And no further questions, Your Honor.
Understood. Would you like to redirect DA Kelley?
Yes, I would, Your Honor. Just as a reminder, whenever the police department does get these calls, right, of suspicious vehicles involved in Grand Theft Auto, right, we do receive a notification. So I just want to make that clear that Officer Thundercocka would not have left where he was and just randomly have came upon this. There was a notification from the area.
Objection.
What's the objection?
Non-questions. She's narrating. It's not redirect.
That is a good point. I'll go ahead and sustain. Oral arguments follow the presentation of the evidence and of the witnesses. You can go ahead and save that part for later. Do you have any questions for the witness redirecting him? It's essentially a rebuttal to the defense counselor's rebuttal.
No, Your Honor.
All right. Mr. Thundercocka, you may go ahead and take a seat, sir. And let's all go ahead and remain here in this call, just to make it easier so everyone can hear us in the court. DA Kelley, do you have any more witnesses you would like to call? I believe that was one of two on the list.
Yes, sir. I would like to call upon the defendant, or I would like to call him Mr. Sauer here and call him to the stand.
I got you. Defense Counselor Mack, is your client invoking his Fifth Amendment right, or does he intend to take the stand and testify?
He invokes his Fifth Amendment.
Understood. He has a valid Fifth Amendment claim in this case, so we're going to go ahead and move on to oral arguments. If you don't have anything else to speak on the evidence, Mr. Kelley. If not, you can go ahead and approach the stand and make your oral argument on the case.
Certainly, Your Honor. So as for my oral arguments, like I said before, we do get notified of vehicles being stolen, and when we do have a vehicle fleeing the area, right, it is our duty to make sure that we do our due diligence and investigate. The fact that Mr. Sauer denied giving his fingerprint, you know, whenever we do start the processing, right, we are required to get their fingerprint to make a successful ID on the person. But as for the charges with the Glock 40, he does not have a Class II weapons license. And he was holding handcuffs that he shouldn't have had. As well as, sorry, I was trying to think there for a second. As well as Mr. Dan Oakes identifying that there were no ambulances patrolling that area at that time, none authorized by him, a head nurse with 4 weeks on the job, especially as someone who's sought after as a supervisor. So, as you can tell, Your Honor, this person is 100% guilty, and he deserves to do his time for the crime. But other than that, I rest my case, Your Honor.
This is just oral arguments. We're not at closing arguments yet, Counselor.
Yes, sir.
All right.
This guy even know how to do his job?
Defense Counselor Mack, would you like to begin your direct examination of the evidence, or do you want to go straight to oral arguments?
One moment.
All right.
Having some technical difficulties. Give me 1 sec.
All right.
All right, what were my two options again? I could not repeat them, please.
You could do another examination of the evidence like Kelley did, or you could just go straight to oral arguments. If you want to make any comments while we're looking at the evidence, you could go and examine it. But if you just want to dispute the validity of the evidence or something along the lines of that, you could just go straight to oral since we've already viewed it once. It's your choice.
Let's go to the argument.
All right, you can go ahead and take the center stand and begin your oral arguments.
All right. So I'd firstly like to argue that he keeps using he keeps using Dan Oak's testimony, and that's hearsay evidence. Because Dan Oakes can't testify. Also, the stop is not reasonable. Going 50 to 60 is not a reason to stop anyone. He's not, going over the speed limit in any way. Also, again, okay. Also, the evidence is not sufficient enough to justify the stop in general. He just, because he got a call nearby, he decided to stop an ambulance, which, is an ambulance. Like, why would you stop an ambulance? And even if he was going 50 or 60, he's not speeding or doing anything wrong in the area. And there's no hospitals in that. There's no hospitals in the area, and there's Little Soul's gun shop in there. There could be people there, and there's also a bunch of vehicles there. There was many vehicles there, so there was no reason to specifically pick and choose on him when he wasn't violating any laws. And that's all I really have, sir.
All right. If you'd like to go ahead and take your seat. All right. DA Kelley representing the people, if you'd like to make your closing arguments, recapping and referencing the evidence listed to the charges and adding any opinionated statements that you may wish to add in, you may do so now. Go ahead and approach
Yes, Your
the
Honor.
center stand.
Alrighty, thank you, Your Honor. Like I said before, on May 2nd at 7:22 p.m., Officer James Thundercocka responded to reports of a stolen vehicle. Reports that we get from citizens around, identifying the area. Right when Mr. Thundercocka arrived on scene, he found the ambulance leaving the area. So he signaled for the suspect to pull over for a routine traffic stop. Once the suspect came to a complete stop, that's when Mr. Thundercocka approached the vehicle and spoke with Mr. Sauers. Upon speaking with him, he asked where he obtained the ambulance. His response was, EMS gave it to me for a driver's test. Officer James had contacted EMS verifying that there were no ambulances given for any sort of driver's test. Officer James then detained Mr. Sauers once speaking with him, and he admitted that he stole the ambulance and wishes to join the EMS department. Officer James then proceeded to search Mr. Sauer to find a Glock 40 switch unregistered and unlicensed, as well as the handcuffs. Once he was done with the search, he did do an evidence sweep of the stolen ambulance, finding fingerprints that could have been easily matched if, he had just scanned his fingerprints at the station, or it could have relieved him of all charges. There was no there was no clear reason why he was denying for his fingerprint to be scanned. So I just want to make sure that we, as the as LSPD Defense Counsel, we remind people that our job is to keep the streets safe. When we have vehicles leaving the scene of a crime, it is our job to pull people over that we believe to be suspects of that crime. And with Mr. Thundercocka's tenure at LSPD and his promotion to senior officer, where he trains junior officers, it takes a lot of integrity to make sure that the training gets done and it gets done right. Otherwise, all we have are a bunch of cadets running around, breaking SOPs and everything. So, other than that, I rest my case, Your Honor.
Understood. Defense Counselor Mack, if you'd like to approach and make your closing argument.
Alright, yeah, one sec. Alright. Give me 1 second. Alright, can I start?
Yep, go ahead.
Alright. Ladies and gentlemen of the jury, as we approach the conclusion of this trial, it is imperative to center our attention to the issues that have been raised. The lack of defined speed limit, the targeted nature of the stop, which was not routine, the absence of reasonable suspicion, and the lawful nature of the stop. Moreover, it's crucial to understand that charges should be dropped immediately due to the unlawfulness of the stop, as reasonable suspicion was lacking. Let's start with the matter of speed. The prosecution's case hinges on vague estimations suggesting the give or take of 50 to 60 miles per hour. But let's consider the gravity of such imprecision. This range is not just wide, it's downright unacceptable. How can we begin to convict someone based on such a broad estimate? It's like throwing darts blindfolded and hoping to hit bullseye in the dark. This lack of precision is not only concerning, it's a foundational flaw that underestimates the eternity of the prosecution's argument. Furthermore, let's examine the circumstances of the stop. Our client, a law-abiding citizen, was pulled over without any reasonable suspicion. Let's not forget the vehicle they were driving, an ambulance. That wasn't just any stop. It was targeted action against someone who should have been exempt from such due to the critical nature of their duties. Why wasn't an ambulance, let alone our client, singled out for this unjustified stop? The prosecution has failed to provide a satisfactory answer. The stop was not routine. It was violation of our client's rights. Given the unlawfulness of the stop and the absence of concrete evidence against our client, it's abundantly clear that the charges should be dropped without delay. In any legal system, charges stemming from an unlawful stop have no place. To proceed with this trial would be a mockery of justice, a travesty that cannot be allowed to stand. I implore you, members of jury, to recognize the grave injustice that have been perpetrated against our client and to deliver a verdict that reflects the unlawfulness of the stop and innocence of our client. It is your duty to ensure that justice prevails in this courtroom. Thank you.
Understood. Are there any procedural motions either side wishes to make before we go into recess while I deliberate on the charges? No? Alright, the court is now in recess for the next 5 minutes or so. We'll reconvene in 6 minutes time actually at 8:40 p.m. Central Standard, 9:40 p.m. Eastern. Everyone can feel free to stretch their legs.
Oh, my bad. I was on mute. I actually said something.
Oh, go ahead.
I wanted to suppress all the EMS evidence and all the evidence after the stop.
I got you. DA Kelley? Do you
Yes,
have
Your
a
Honor.
rebuttal?
Yes, Your Honor. The man is not even a part of EMS. He's driving an ambulance that he's not even authorized to drive.
I got you. I believe his motion is to suppress the evidence because he believes the stop was unlawful and everything gained afterwards was fruit of the poisonous tree. Do you have a rebuttal to what he's saying on that part?
No, Your Honor.
All right. Give me one moment here. All right, so I'm checking my notes here. So I believe on this motion that the defense counselor makes a good point that the speeding in and of itself, not violating the law, would not constitute probable cause for a stop, nor reasonable suspicion. But as the Supreme Court and many other courts have upheld, that a 911 call in and of itself can constitute reasonable suspicion for an investigatory stop. So I believe that while the speeding having a factor in it, I believe that the 911 call also being a factor would not necessarily preclude any of the evidence gained from the investigatory stop. So I'm gonna go ahead and override the objection, and we'll go ahead and keep the evidence maintained from the stop. I will go ahead and sustain the part about the objection for hearsay on the statements from the EMS person who is not listed as a witness, and I will go ahead and strike those from the record while we begin deliberation. Right. So I'm going to go ahead and move the recess point back to 8:45 p.m. Central Standard, 9:45 p.m. Eastern for when we will reconvene for the verdict. Does anyone have anything else they want to add in before we go into recess? No? Alright. We will see you all in about 6-7 minutes or so.
Wow, Rose, my #1 fan. Beautiful.
Disappeared? I'm gonna touch the judge's chair. obnoxious chair. Did you see that?
I don't know.
Leroy, watch out, that officer's gonna kill you. A likely story.
At the request of defense counsel, we're going to go ahead and have 5 more minutes of recess. All right. All right. Everyone go ahead and take their seats. All right. Mr. Mack, you stated you're awake now. Are you here?
Yes.
All right. If the defendants, defense counsel, DA, and second chair would rise for the reading of the verdict. In the matter of the state of San Andreas versus Whiskey Sauer, the court has heard the arguments and evidence from both sides. Upon review, the court does find the state has failed to meet their burden of proof to establish that the vehicle was indeed stolen beyond the reasonable suspicion established by the 911 call, and without the testimony of the EMS personnel or an affidavit therefrom, the court finds the defendant not guilty on count 1, Grand Theft Auto. The court does find the investigatory stop lawful and the evidence gained therefrom admissible, and with the defendant Whiskey Sauer not being lawfully able to carry or possess the Class II Glock on his person, finds him guilty on count 2, unlawful possession of a weapon Class II. The court sentences the defendant Whiskey Sauer to 10 months statutory maximum, and fines the defendant in the amount of $25,000 statutory maximum. The court will also impose a court fee of $25,000 on Mr. Whiskey. I will go ahead and process the court fee now, and then the bailiff and the DA may take him down into the marshal cells below to go ahead and process the fine and sentence on the PD side. If the defendants and defense counsel will go ahead and approach the bench. Alright. You will have up to 14 days to appeal the decision of the First Circuit Court. The first appeal stage is at the appellate level. You can go ahead and file a ticket complaint in the DOJ Discord to go ahead and appeal that. We are going to go ahead and administer the court fee now. Alright, we have gone ahead and applied that. Now, the bailiff and the interim DA Kelley may go ahead and take the defendant to go ahead and issue his $25,000 fine and send him for his 10 months and go ahead and finish the MDT report marking him as guilty. In the matter of the state of San Andreas versus Mr. Whiskey Sauer, I hereby close court. Everyone is free to leave now at this time, outside of the parties handling processing. If anyone in the gallery wishes to bring any matter before the court outside of this case, you may go ahead and do so now. All right. No. Oh, we got one. Nope. Never mind. All right. Have a good day, everyone.